the petitioner for 3 more months to stop. The facts of the case are that the petitioner was arrested on 6/10/2023 in connection with the anti-corruption case by the police. Full stop. He was suspended from the service by order dated 14/10/2023 in terms of sub-rule 2 of Rule 6 of Assam Services in bracket Disciplinary and Appeal Rules 1964. That is from 6/10/2023. Thereafter, a show cause notice was issued to the appellant under Rule 9 of the Rules of 1964. Taking into consideration the facts of the case, the respondents, while reviewing the suspension order, has extended the suspension period of the petitioner for 3 more months wide order dated 8/6/2024. The learned single judge, after taking into consideration the order of extension of suspension period, has observed that the authorities has considered the complaint that has been made against the appellant in relation to the demand of bribe for giving favorable orders to the employees, and this conduct of the appellant caused embarrassment to the department, and therefore we thought it fit to extend the suspension period of the petitioner by order dated 8/6/2024. Having heard the learned counsel for the party and after going through the material available on record, we are of the view that the discretion exercised by the learned single judge in passing the impugned order cannot be said to be unjust or unreasonable in the facts and circumstances of the case. Hence, no case for interference is made out. Writ appeal is dismissed.
Lordship, Lordship, may I pray that the observation be given that they should complete the.
However, it is expected that the government shall conclude the disciplinary proceedings pending against the petitioner expedition. Against the appellant expedition.
Applies.
Item number 9.
May please, Your Lordship. The writ appeal stand was that while the writ petition was disposed of in the motion stage, I was not heard. I'm sorry, I took a different method. Mine was 11. I thought it was 9.
Huh?
Erroneously, I thought it was 9. I stand corrected, my lord.
Item 9.
It's 9.
It's 9. Mine was 11. I thought. No, move 11.
Who is appearing for? No, you can argue 11 also. Yes. Mr. Gogoi. Password for the time, yes.
Respondent number 1 for J. Chetri. J. Chetri, respondent number 1.
Respondent number 1,
For respondent number J. Chetri.
for the timing we are passing.
Item 10.
May it please, Your Lordship. My Lord, my only case would be the rules speak otherwise, my Lord. If Your Lordship would kindly come to the rules, my Lord, which Your Lordship will find at page 64. The rules at page 64, my lord. Rule 9. Method of recruitment, qualification, age limit. And if your lordship would kindly come to the fourth column, by direct recruitment, then lordship will kindly come to 2. Must be practicing as an advocate in the court of civil and criminal jurisdiction on the last date fixed for receipt of the application. And my lord, the last date for receipt of application was 24/6/24, on which date, my lord, the petitioner was not appointed to grade 3 of the Mizoram Judicial Service. She was an advocate. My lord, the advertisement was dated 31/5/24 for grade 1, and last date of receipt of application was 24/6/24,
That is for grade 1.
grade 1, my lord. And the petitioner was appointed to grade 3 on 17/10/24. So therefore, I think lordship would like to examine the matter, my lord.
No. You just, you have to answer certain questions.
Yes.
At
Now,
the
my lord,
time of, you were selected on which date?
I was appointed, my lord, to grade 1 on 19/3/25.
19/3/25. 25.
Yes.
On that date, what was your status?
On that day, my lord, of course, I was grade 3, because I was appointed on 17/10/24.
On that day, that is absolutely against the decision of the Honorable Supreme Court.
No, my lord.
In the
Honorable, my lord, if my lord, that's the distinguishing factor in my humble submission, my lord. In the cases of the Supreme Court, which we have seen, my lord, there the rules were under challenge, where this prohibition was there, unlike in our rule.
There is more judgment.
So, my lord, the latest judgment is there.
There is more, sir.
Yes, there is more.
There is more.
There is more. Please have the judgment, my lord.
Yes.
401. Please come to para 3 of the judgment, my lord. The facts. If your lordship would kindly come to para 3 at page 415, my lord. This was the contention. It is argued that Article 233(1) and 233(2) interior deal with direct recruitment, as it is apparent from the Constitution Bench decision of this court in High Court of Punjab and Haryana versus so-and-so. The rules framed by various high courts disqualifying members of subordinate judicial service from direct recruitment to higher judicial service are not in consonance with the law laid down in Chandra Mohan Rameswar Dayal and the provisions contained in Article 233. The rules which completely cut off one stream and provide only one stream of direct recruitment, then the High Court rules would have to be declared ultra vires, being violative of Article 233. So this was the challenge, my lord. Our rules does not say so. Our rule.
But ultimately, what the Supreme Court.
No.
held-
Lordship will, that's why my humble submission would be, a judgment is rendered in the facts of this case. But here,
Please come to para 45.
yes. In view of the aforesaid discussion, we are of the opinion that for a direct recruitment as district judge against the quota fixed for advocates, pleaders, incumbent, has to be a practicing advocate and must be in practice as on the cutoff date and at the time of appointment. This is the line. Perhaps Lordship would like. Yes. Please. And at the time of appointment, he must not be in judicial service or otherwise service of the union. For considering the experience of 7 years of practice as an advocate, experience obtained in judicial service cannot be equated, combined, and advocate pleader should be in practice in the immediate past for the 7 years and must be in practice while applying on the cutoff date fixed under the rules and should be in practice as on the as an advocate on the date of appointment. But my lord, my understanding is subject to what your lordships may say. Para 45 has to be understood in the context of the facts of this case. Here there was a rule. If there would have been a rule like the one before us, my lord, lordship will kindly appreciate one thing. The Mizoram Judicial Service rule has been framed to effectuate Article 233(2). If the rule is framed to effectuate, then my lord, the rule has to be given effect to. The rule says on the last day.
Yes,
My lord, if your lordship should kindly come to Article 233(2) for a moment, my lord.
yes.
A person not already in the service of the union or of the state shall only be eligible to be appointed a district judge if he has been for not less than 7 years as an advocate or a pleader and is recommended by the High Court for the appointment. Now, my lord, regarding the services of union or state, there was some confusion at one point of time. Supreme Court has settled there has to be judicial service here. Now, my lord, the second limb is, what is the meaning of eligible to be appointed? Eligible to apply.
Certainly.
Now, my lord, to effectuate this Article 232, the rule has been framed under Article 309.
Whatever it may be, sir.
Now, supposing, my lord,
After taking into consideration the provisions of this article, the article 33 and the other provisions, if the Supreme Court has held that a person should be practicing advocate just before appointment. She was not 17/10/2024 to date of her appointment. She was a grade 3 officer.
my lord,
She has not resigned from the service.
no, my lord, no, my lord. No,
And,
no, even resignation will also not cure that. The Supreme Court has said, if somebody resigns, then also it don't be then also it is not available.
Even though if suppose she has not resigned, even she has not informed. Problem was this, that she is already appointed as a grade 3 officer.
That of course we don't know, my lord.
Because the problem is that the grade 3 selections are to be made by the Public Service Commission.
Right.
The High Court has no role there. He was appointed, she continued up to that. This was the problem, sir.
No, my lord, I was only submitting for your lordship's kind consideration, my lord.
Ask them to find a reply.
Yes.
Take care.
Now, I do understand I have to overcome this judgment.
Yes, this is not the problem.
Hmm?
Okay. This litigation is done by the petitioner. Order detail. There are 2020. Where the appointment of the This impugned order 28/3/2000.
Yes, my lord. Yes, yes. There are two orders.
One is by the
one-
state-
Yes,
state government and another
page 59 and 61, my lord.
page 50.
59
And 61.
and 61.
59 is passed by the state government.
59 is by the state government.
Is whereby the appointment of petitioner or to grade one of the Mizoram Judicial Service
Into,
Services.
I wanted to go to the other.
By notification dated 19/3/2025 was revoked. Full stop. The petitioner, while selection and appointment as grade one officer in the Mizoram Judicial Service was serving as grade three officer in the Mizoram Judicial Services. Learned counsel for the petitioner has submitted that since the Mizoram Judicial Services rules and he says that only at the time of applying for the post of grade one, a person should be a practicing advocate and therefore even though if the petitioner is working as grade three officer at the time of her appointment, her selection and appointment in the post of grade one,
Simple.
the same, grade one, the said appointment cannot be said to be illegal. You should notice, Mr. You are appearing for? Respondent number 4 has nothing to do.
Basically, High Court, my lord.
High Court is.
I
Mr.
want
PJ
to-
Mehta,
In fact, my lord, the reasons will know only from the affidavit, my lord.
That's why. Mr. PJ Mehta,
1 to 3. No, that 2, I think.
is put an appearance on behalf of the respondent number 1, 2, and 3.
Yeah, then what?
Mrs. So-and-so is appearing on behalf of the respondent number 4. Full stop. You are in receipt of copy of
We'll have to give some more copies.
the memo of the appeal along with the requisite documents we supplied to Mr. Mehta and the Ms. So-and-so, Mrs. So-and-so. Counter to the affidavit be filed. When
I have to, after 4 weeks, my lord.
after 4 weeks, list after 4 weeks.
Diplomatic.
Item 11.
Yes.
May it please your lordship. But before I start, Miller, I left my brief at home, so I borrowed my colleague's brief. I left my file at home inadvertently again. He was kind enough to give me the 5 minutes. Miller,
You,
no, I left my file at home at the chambers, Miller. My colleague was kind enough to bring me his file for the
you
press.
take this.
No, it's,
Please take this. Go to-
I just indicated. Miller, this is a case where the writ petition was disposed of at the motion stage without issuing any notice to me,
Okay, we are hearing you. What is your argument?
my lord.
We
3
are
dates,
hearing you here only.
my lords. 3 dates, if lordship may kindly think about. First is 10th of April, 22. 10th of April, 22, my lord, when the writ petitioner was removed or, suspended as a secretary.
Fine.
10th of April. This, my lord, finds at page 71, 72.
Yes.
Now, 8th of June, 22,
8th of
June, 22.
Yeah.
The Deputy Director, Food, Civil Supplies and Consumer Affairs, Barpeta, as a proof of the Deputy Commissioner Barpeta, he allows me to continue as the in-charge secretary.
Where is that order?
Page 32.
32.
May I read that?
Read.
As approved by the Deputy Commissioner Barpeta, white file number BSM 33/22 at note sheet number 7. Sri Kamal Goswami, son of late Mahendra Goswami, is hereby allowed for lifting and distribution of food grains and other articles, if any, available in the godown in respect of MS Deshbhakta in the greater interest of consumer affairs under federal order. Sri Kamal Goswami, in charge secretary of Deshbhakta so-and-so, will be personally responsible if an irregularity occurs in lifting and distribution of food grains. So my in charge status is stabilized,
And what is otherwise, what is your post?
my lordship.
Otherwise,
I was there in the society. I was brought in as the in charge secretary because he was suspended.
secretary, so with this order,
My lordship.
prior to that, what you,
Member,
huh?
I'll be a member of the society, my lord.
Member of the.
Member of society. I'll brought in as the in charge.
It's a stopgap arrangement.
Stop paper arrangement. Perfectly stop
So
paper.
what is your right ultimately, the stopgap arrangement? You
My-
want that this stopgap.
No, no, no. I
arrangement should-
certainly do not want that, my lord. What I say, the writ petition was projected as a challenge to the suspension order without indicating that at page 49, that is 31st of October, he was discharged. Challenge of
was
suspension,
discharged,
the writ petitioner as a secretary.
maybe. What
He
the
was-
ultimately, what the.
Honorable single judge directed that since his suspension order be considered by the registrar of this department, Lord. So suspension order followed by a removal order. The removal order is not even brought on record.
So how it matters?
My lordships.
They ultimately, the registrar will record the findings.
But this-
He has already.
so far as
therefore
I-
this Suspension order.
True,
Whatever
true.
it may be.
So far as
challenge to
I
the
had been-
Suspension order is
My lord,
infructuous.
so far as I had been arrayed as a private respondent therein.
That's why only we are hearing.
Absolutely, absolutely. My lord. My only thing is that he did not bring on facts what ought to have been, and my right goes.
Fine, but how
Now,
your
present,
rights are affected by it?
just
You are
because I was.
simply asked to do stopgap arrangement as a.
Yes, nothing beyond that. No, I'm fair to that. But one difficulty might come in today, if I may address an officer of the court. During the proceedings, as they move on, my lord, Honorable Single Judge in a different case was pleased to pass an order that the registrar has no jurisdiction to decide in a case of removal of a secretary appointed by the board.
Okay, then.
I'm on that.
The registrar will say that I don't have any jurisdiction.
This order, if I'm to understand correctly, has been challenged by the department in a writ appeal which is
Yes.
pending.
Yes, we have issued the notices.
My lordships.
Yes, we have issued the notices.
If I
This
pray,
is Manish Chaudhary's order is there.
my lordships,
We have
if I
issued the-
pray for a remand, my lord, because otherwise everything goes this way.
What is your right affected? You please show us, sir.
My lord, I was appointed as in charge, not allowed to utter a word in the writ petition. The writ petition is in gross
That's why only
separation.
we are giving you the
I know.
opportunity. Okay, what is your right? Which right of yours have been infringed?
But termination order is not even projected and a suspension order is brought in the challenge.
Forget about it.
No,
What right has
That's-
been
I
infringed?
have to apprise the honorable court of that only, and that was my part, nothing more.
But you have to show us that with this order, your rights have been infringed. You were simply asked to work as a secretary as a stopgap arrangement.
Had this aspect been brought to, it's an ifs and buts, my lord, now. Had this been brought to the notice of the honorable single judge for kind consideration, perhaps the order might not have followed. I leave it to lordship. my lord. Because if I was there, and this was my legitimate right to project the correct facts,
Sir, Rene,
or whatever.
absolutely right. Ultimately, you have.
Ultimately-
It is your right to
ultimately,
remain as a secretary because you are simply asked to.
It is not at all a challenge to my being the in-charge secretary. It's a stopgap arrangement. What I say, when you implead me as a respondent and not as a pro forma respondent, certainly and invariably, I must be heard.
So that's why only we are
When-
giving the opportunity.
I'm
Again,
grateful, my lord.
you take this petition as a writ
If-
petition,
my
and
lord.
argue before you assume that you are arguing before the learned single judge. Now come.
My lord. Very well. I take it to that.
Now come.
I take it to that, my lord. Look, a writ petition on, if I put it very softly, incorrect facts.
Sir, you can put it hardly
Well,
also.
a writ petition on incorrect facts need not succeed, my lord. when I projected the correct facts on record, but it goes other way.
You're right, your concern is very
And
genuine.
incorrect
But
facts,
ultimately, for passing an order, sir, at least in your favor, you.
no, not in my favor
your
at all.
continuance- You want your continuance as a secretary.
No, not at all. Today, tomorrow, if
Not
this,
at all, then why you come?
because I was arrayed as a respondent and not as a performer.
But ultimately, sir,
Ultimately, without notice, it goes, Milord. Therefore, let the honorable single judge take a call on that. And in view of the Bikrampur judgment, lot of things may happen.
taken care, insofar as the respondent concerned, since the engagement is a stopgap arrangement, the said aspect of
Correct.
need not to come in the way of the passing appropriate deemed justified in the facts of the case.
Absolutely correct, because honorable single judge was not even apprised that he was terminated. This fact was not noticed.
Even tomorrow, they may appoint some other person.
Yes, yes, yes.
Secretary, they are.
Then my cause of, no, we'll cross the bridge as it comes. That situation has not come with all fairness.
Ultimately, stopgap arrangement.
Stop, no,
Only
there is
you
not a
are
challenge to my arrangement,
asking
Milord.
for the duties, that's all.
With utmost humility, Milord, it's not even my
And
case.
who is working at present?
I am continuing.
Then.
No, they may
how
remove me.
you are aggrieved?
They may remove me. It was
How-
not a
how
challenge.
can they remove you?
It's at their wish. So I stay. Now Bikrampur comes into way. I cannot go
No,
to
no,
registrar.
No, even though you just now you have admitted that they can very well appoint any other person as in charge secretary.
Without being arbitrary, irrational, or discriminatory, Milord.
Discriminatory,
They-
what
they
right
did
you
not-
have? Stop
No,
the
I'm not-
arrangement. They
I'm
can
not-
ask anybody
But
to.
tomorrow they may say that we don't like the way you dress up and come to the office or you go.
Yes, they can.
In a
Very
challenge, very well, Milord. In a challenge to that, when I come to the court.
Stopgap arrangement.
Correct. But in a
Yes.
challenge to that, when I come to the
Even
court.
they can say, we don't like your face even. Yes, they can very well say.
But today, that's not the
Sir, a
situation.
stopgap arrangement between when the secretary was suspended, you were simply asked to do some duties of the secretary. What right
Well,
ultimately?
I am not even protecting my status or position.
So then why you oppose this court, sir?
Let the correct facts be on record. Then honorable
Sir,
court
that
takes a
is,
call.
Please.
That's
Sir,
all.
first of all, for the purpose of getting any relief, you have to show your rights.
My right was I was impleaded. I wanted
That's
for
why
the
the
correct
learned
facts. That's
judge has rightly observed that in for so far as the respondent concerned, since his engagement is stopgap arrangement and the said aspect, the matter need not come in the appropriate order justified in the facts of the case.
but today the suspension order goes. If he's terminated, even the order
Sir,
cannot be
you
carried.
are
forward.
arguing so many things. Registrar has no jurisdiction.
But that is as
He
per
has
the judgment.
already been discharged. He'll take into consideration whether he has a jurisdiction or not, and he has already been discharged.
If Lordship
Then his
permits,
suspension order, the challenge to the suspension order is of no use, infructuous. He'll take care of that.
very well. With the observation, my lord, this order that he was terminated be a part of the order.
Why should he?
No, he was terminated. I've placed it, my lord.
They'll consider it. The
But because in the writ petition, it was not even projected. Now I come in and argue this, my lord. I place it on record.
Nothing. We are from. This writ opinion is filed by. The eligibility order dated 28/6/2023. Whereby, 23, whereby the learned single judge has disposed of writ petition number 3595 of the 2023 filed by one Fatir Rahman. Respondent number one in this writ appeal. Therefore, the learned single judge is disposed of. Writ petition number so and so filed by Fatir Rahman. Respondent number so and so. With the direction to the registrar of the cooperative society to cooperative societies to invoke his power under section 38, read with section 49L of the Assam. What is it? The Act, whole Assam Cooperative Societies Act 2007, and pass appropriate order so as to redress the grievances of the Fatir Rahman in the light of the observations made in the order. The brief facts of the case are that the respondent number one hearing was working as a secretary of the Desh Bhakt Samabe Samiti and was suspended on the basis of a resolution adopted by the Board of Directors of the Cooperative Society. The said suspension was challenged by the respondent number one herein before the writ court on the ground that the Board of Directors of the concerned cooperative society did not have jurisdiction to pass the suspension, the pass of the order of the suspension. Full stop. Learned single judge taking note of the provisions of section 38 and section 49, capital L of the Act of 2007 has disposed of the writ petition with the direction to the respondent, to the registered cooperative societies to pass appropriate orders so as to redress the petitioner's grievance, redress the respondent number one herein grievance regarding his suspension. Full stop. The present writ appeal is filed by the appellant who was arraigned as respondent number 5 in the writ petition for the reason that during the suspension period of the respondent number one herein, he was directed by the society concerned to act as in charge secretary of the same. Full stop. The learned single judge, while disposing of the writ petition, has also observed that so far as the appellant is concerned, since his engagement as a secretary was a stopgap arrangement, and therefore the said aspect of the matter need not come in the way of the passing appropriate order by the registrar as directed. Full stop. Learned counsel from the appellant has submitted that some of the facts which are relevant and important has not been disclosed by the writ petitioner, by the respondent number one herein before the learned single judge, which are he has already been discharged from the services on
My lordship.
discharge.
Lordship,
He was discharged on which date?
10th of April.
10th of April.
No, he was discharged on 49th, just a moment, 31st of October,
October of,
22.
he was discharged from the post, he was discharged from the services by the cooperative societies on 10th of October,
2022, page 4,
31st of October,
October, 31st of October, 22, page 49.
2022. Learned counsel has also submitted that as per the recent judgment passed by the learned single judge, the registrar cooperative societies also has no jurisdiction to examine the validity of the suspension order passed by the board of directors. At the same time, learned counsel for the appellant has frankly admitted that the respondent number, that the appellant herein as such has no vested right to remain, work as the in charge secretary of the concerned cooperative society. However, society, but Mr. Banik, learned counsel for the appellant has submitted that this writ appeal is filed only with the intention to brought true facts before this court. Full stop. Having heard the learned counsel for the appellant, and after going through the material available on record, and as per the own admission of the counsel for the appellant, where the the appellant herein has no vested right to remain, work as in charge secretary of the concerned society in the absence of a regular secretary. No interference is called for in the impugned order. However, so far as regarding however, it is expected that the department shall take into consideration the factum of discharge of the respondent number one herein from the services in October 2022 itself, at the time of taking any decision pursuant to the order passed by pursuant to the impugned order, pursuant to the impugned order passed by the learned single bench. With these observations, the writ appeal is disposed.
I'm grateful, my lord. Obliged. It serves the purpose now. It serves the purpose without even going.
It doesn't have to
No, absolutely.
serve the purpose. You just want to
Lord,
remain
Lord.
work as a secretary for indefinite period.
No, until they are upset, I'm still there.
Sorry.
Grateful.
Item 13,
Yeah, please.
When this FDR was placed, when this FDR was placed,
Yes, your lordship.
this FDR, which was created only in 2015,
Yes,
when
sir.
it was placed.
It was placed in 2008, your lordship.
2008, it was not even created.
No.
This fixed deposit was created in the year 2015.
15, your lord.
When it was placed, this letter says, this initial letter, this annexure A speaks only about the NSC of rupees 2,08,000.
8,000. Yes, your lord.
So the subsequent FDR, which she created only in 2015,
Yes.
how you can this restrict the realization of that FDR?
By way of lien, your lordship.
Which lien,
Because
sir?
your lordship, what
Sir,
was
any person,
Huh.
if suppose a property is whatever the NSC or fixed deposit they have pledged against a loan,
yes,
the other FDR
yes,
or some other NSC which was not placed, that can be
yes. In case of default, your lordship, section 171 of the Contract Act,
171.
one of the Contract Act,
It's
and your lordship, they have not rescinded their contract. It is an enhancement in the year of 2009
sir, enhancement with additional guarantee.
with additional guarantee for the additional amount.
For the additional amount,
Yes.
this guarantee was not given by her. The additional amount guarantee was not given
No,
by
your
her.
lordship, that was not.
Sir,
Your lordship, the guarantee.
just a.
Which was not placed.
Contract and then- This is bizarre, sir.
No, your lordship.
This is bizarre. Yes, what is it?
Yes, sir. Your lordship, there is no denial that the guarantee is a continuous guarantee.
It's a continuous guarantee up to 2,08,000.
No, your lordship, it cannot be said
Then
because in the contract it has been specifically that to the whole amount.
there is that.
That is, they have placed only sanction letter.
You place it on record, which is that?
Yes, the guarantee I will bring, your
Where
lordship.
is that?
No, your lordship, I have not bring it by way of.
Why, sir? You should have, along with your reply,
Yes,
you should have-
because I was just by way of judgment, I think that the matter will be suffice, your lord.
It is- She created an FDR in another bank.
No, another
Apart
bank
from
we
your
cannot
bank,
because entity will be changed, your lordship. If it is in another bank, then we have no right because entity will be changed.
After that, you make, yeah,
Your lordship, kindly para 16, your lord.
yes.
That is on the principles of the continuing guarantee. The position was cleared by the decisions of the court in the Sitaram Gupta versus Punjab National Bank, whereby it was held that it was not open to a party to revoke a guarantee when he has agreed, it being a continuing one, and thus would be bound by the terms and conditions of the agreement executed at the time of entering into the guarantee. So it is in continuous guarantee. And then your lordship, 19, your lordship. Your lordship, it is not a novation, it is an enhancement.
No, no. Yes,
Yes, your lordship.
now come.
It might be useful at this juncture to turn the decision of this court and Lata Constructions versus Ramniklal Saha, whereby this court held that if the right under the old contract were kept alive, even after second agreement, the right under the first agreement had not been rescinded, then there was no substitution of contract and hence no novation.
But certainly this 2,08,000 which he has given, it is up to the closure of the loan account. No doubt about that.
No, no.
But the other money
Your
deposit,
lordship, we are just mixing the NSC with continuing guarantee.
the continuing guarantee
Pledges
in relation
different
to
issue.
any other deposit
Yes.
by a guarantor is supposed to use for the purpose of satisfying that loan account.
Yes, your lord. He has to satisfy.
That is-
Your lordship, I will bring the loan agreement before your lordship.
you,
It will be.
you bring that loan
Yes,
agreement,
yes, yes,
or you release this.
yes.
How much amount of this FT is?
This is 1.5. Now it has become to 1.77 or something. It is now
77 lakhs.
lakhs.
Go through this, judgment.
Yeah, I will go through this. But I don't think it
I
is
am
a
giving
This
continuous.
on Wednesday, you bring
Yes,
it
yes.
on this Friday, next
Yeah.
Friday. It's on 23rd.
Yes, your lord.
You bring that by way of an additional affidavit.
Because pledge mortgage is separate issue and guarantee is a separate issue. Your lordship.
Passport meter 9.
That learned concept respondent bank, this short time for producing the contract
Guarantee agreement.
guarantee agreement executed between the petitioner and the bank.
Yes.
I'm appearing for respondent number 1, Lordship.
So no one is appealing on behalf.
They do not have case, Lordship, electronic signs.
That is another thing. Now you have been appointed in place of her.
No, Lordship.
The court has
Dismissed, allowed my petition. My petition, I was.
allowed your petition and also directed to give you appointment. You are respondent number 1.
1, yes.
You were the petitioner, na?
I was a writ petition.
So this para number 19 of the judgment says that the
Yes.
consequently inclined to issue direction to offer appointment to the petitioner, namely Suruj Gogoi.
Suraj Gogoi, Lordship.
So you have been provided appointment
No, Lordship, I have not appointed till date,
till date.
Lordship. I'll have to take instruction regarding that, Lordship.
Whether you have been appointed or not. And because it's 2 years, almost 2 years have
Lordship.
passed.
I'll have to take instruction, Lordship.
None is appearing on behalf of, none appears on behalf of the petitioner. Even in second round, then the matter is called twice. However, none has appeared on behalf of the petitioner. This, in the interest of justice, matter is adjourned
Date.
for 3 weeks.